Hi, my name is Nadil. Today we'll be diving into the civil litigation process in Malaysia. Before filing a claim in court, there are three things you need to know. Number one, do you have a solid case, or in other words, cause of action, which give rise to your claims and the reliefs you're asking for? Number two, is your case within the legal time limit, or in other words, within the statute of limitation? And number three, do you have the evidence to support your case? One thing to note is that often disputes can be resolved before even going to court, and this is done by first issuing a letter of demand. A letter of demand serves as a formal notice to the other party of your claims, and of course, this can save you a lot of time and money, as you may resolve the dispute even before going to court. However, if it doesn't work, then of course, legal proceedings may be necessary. Now let's talk about the official start of the civil litigation process, i.e. filing a claim. This is done by either filing a writ of summons or originating summons, which sets out your claims. And once the defendant receives the summons, they have 14 days to enter appearance in court. Otherwise, they risk a judgment in default being entered against them. Then we move on to the pleading stage. The pleading stage is where the parties set out their respective cases and the material facts they rely on to establish their case. For instance, the plaintiff will issue a statement of claim, and this is usually served together with a writ of summons, and the statement of claim would put in greater detail the case set out by the plaintiff, and it would set out the material facts which the plaintiff intends to rely on during trial. Thereafter, the defendant would set out their material facts in a document called Statement of Defense or just defense. At times, there may be a counterclaim by the defendant, and that counterclaim would also be put in the same document. After the defense and counterclaim, the plaintiff can then also issue a reply if it's necessary, and if there is a counterclaim by the defendant, then the reply would also consist of the defense to the counterclaim by the defendant. After the pleading stage, there is the discovery of documents or exchange of documents by both parties of the documents they intend to rely on during the trial, and this is usually done pursuant to a court direction during pre-trial case management. Then comes the trial stage, where the parties will tender their evidence, written as well as oral. Oral here means a witness testimony, whereas written usually refers to the documents. The witness testimony, the process is usually by first each party, starting with the plaintiff, producing their witness, and each witness usually would have a witness statement, and that would be the examination in chief part of it, and then there will be the cross-examination by the opposing counsel, and then the re-examination by the plaintiff counsel, and this process is repeated again for the defense case. The whole purpose of this trial process is a fact-finding part of the litigation, where the evidence is collected and determination on admissibility at times is determined at the trial, and at times during a later stage, which we will get into, i.e. the submission stage. Throughout this process, the evidence of each party is being highlighted to the court. Now, then comes the other stage which I mentioned, which is submission stage. The submission stage is essentially the arguments by both parties. Usually, in especially high court, there would be written submissions exchanged by parties simultaneously, and these are called post-trial submissions or submissions after trial. This would detail out the facts relied on by parties, supported by the evidence gathered at the trial, as well as the laws that are applicable to the case, including case laws as well as statutes. Applying the law to the facts as presented by the evidence, the judge will then make a determination, and this determination will be known as the judgment of the court. So this judgment usually comes with a grounds of judgment, but at times the judgment will come first, and then the grounds or the reasons behind the judgment will come at a later time. As you can see, the civil litigation process in Malaysia is quite detailed and thorough. We have adopted it from the English common law system. The aim is to ensure a fair and just process for all parties involved.